Mark Meadows, bad news, had his attempt to remove his case to federal court denied. He's being prosecuted in Big Fanny's courtroom right now, doesn't like that, knows that he was Donald Trump's chief of staff, says he's got some federal protections as a result of that. One portion of the way our law works is that when you're in the federal government, you're not supposed to be under attack by partisan hack prosecutors from the state level just filing charges after you so that you can do your job as a federal official. You're a federal official, you've got federal supremacy, kind of the whole reason this law exists. But Mark Meadows asked for a removal to take it from state level court to federal court. The judge denied it. Now, Mark's team unhappy about this. They've asked for a stay, meaning, judge, while we appeal this case, please don't do anything. Just let us appeal it. And then subsequently, they filed an immediate appeal. Now, we'll just hit the highlights from the judge's order. This is what the judge said, and it's a bit of a longer filing. 49 pages out of the Northern District of Georgia. And this is bad news, not just for Meadows, but it's bad news for Trump, because I think that if this case was removed for Meadows, Trump would have just been, okay, perfect, let's go. I'm removing too, and here we go. I'll just join you right up there. But I don't think that's going to happen now, because when Mark Meadows was even filing this in the first place, he had to go through a formal hearing. He had to testify, and all of that gave Fanny's office an opportunity for cross-examination that Trump is not going to want to endeavor this early in the case. So they were kind of putting all their eggs in the Mark Meadows gets accepted into federal court hat. Now that's not looking good. But here's what the judge said. Notice of removal. He says, the matter appearing before me asks the question, has Mark Meadows carried his burden of demonstrating that removing from state court is proper under the law? The judge says, well, having considered the arguments and the evidence, the court concludes that Meadows has not met his burden, and therefore the court declines to assume jurisdiction over the state's criminal prosecution and remands the case back down to Fulton County, Big Fanny's courtroom. And this is a little bit of a surprise. And now we're asking ourselves, how did this all happen? Well, let's see what we can tease out of here. Background: Mark Meadows was the chief of staff. We know that. Grand jury came back, charged a bunch of people with indictments. Meadows got charged with RICO charges and conspiracy. The court declined to summarily remand the case, and we're fast forwarding through a lot of this. They tell us about what happened at the hearing. They also give us the legal standard. They say a federal district court should be slow to act where its powers interfere with state levels. An exception to those general concepts is a special rule is when a federal officer is part of the removal statute. It allows, literally, a criminal prosecution against a federal officer to be removed. That's why they filed it here. It's an incident of federal supremacy, and it's designed to give federal officials a federal forum so they can raise federal defenses. Now, essentially what the judge is saying is that Mark Meadows is not a federal officer within the definition of what it would require to enable him to have a federal defense as a federal official. So, in other words, Mark Meadows was doing some stuff for President Trump as a chief of staff, and he was doing stuff for election candidate Trump as an election candidate official. Some stuff was official. Some other stuff was not really official. Anything within the chief of staff obligations was protected. Anything outside of the chief of staff, which would include things like, I would argue, election stuff, they say, no, it's outside of chief of staff. It's campaign candidate Trump stuff. And therefore, it is not related to Meadows' color of office. Yeah, Meadows asserts that another function of Meadows' role as the chief of staff was to be generally aware of what's going on. He had to prioritize the president's time. He said, though, he was bound by the Hatch Act and couldn't engage in political activity. So political activity is outside the scope. And so this is the court. The court finds that the color of the office of the White House chief of staff did not include working with or working for the Trump campaign, except for simply coordinating his schedule, traveling with the president to his campaign events, and redirecting communications to the campaign. Thus, consistent with his testimony and the federal statutes and regulations, engaging in political activities is outside of the White House chief of staff duties, which means it doesn't count, right? So it doesn't have a federal defense for all of those activities. Now, Mark Meadows obviously says, this is insane, this is ridiculous. He says, nuts. Okay, we're appealing this, filed this immediately, right after the ruling came out, dropped this one, notice of an appeal. He said, notice is hereby given that Mark Meadows appeals to the U.S. Court of Appeals for the 11th Circuit, issued by Judge Steve C. Jones. Now, this is another filing. So in addition to that, which they're filing their appeal to the circuit court, they're also submitting this back to the original judge, right? Now, they're going to say, Judge, look, you're very wrong about what you just did, respectfully. And so we're going to ask you for a stay stay. In other words, don't send this case, don't remand this back down to Fannie's court until the appeal is finished. So they say, Your Honor, we just got your ruling. We hate it. Thanks, by the way, ruling our Friday. And so we're now asking the court to stay the effect of its order. Just don't put it into effect. Put it on hold. You currently declined jurisdiction of this case, and you remanded this back down to Big Fannie's court. But we're appealing this to the 11th Circuit. And they say Mr. Meadows is seeking expedited review later. He's got a right to appeal, and it's important that you stay this case to stop it from this case becoming a shuttlecock. Don't let this case become a shuttlecock, just like in the game of badminton when you just ping pong the shuttlecock back and forth, all day. Federal court, state court, federal court, state court. That's a First Circuit opinion quote, 2021. So they say, Your Honor, look, while Mr. Meadows respectfully believes that you, judge, erred on this matter, this court need not agree to stay the remand order. The court may stay its order if Meadows has a substantial case on the merits and other factors like irreparable harm, balance of the equities, and public interest favor a stay. Here's why you should. The court should issue a stay to prevent the irreparable loss of rights that Meadows asserts under the federal removal statute and under the supremacy clause. So, Judge, if you do not stop this, Fannie is just going to run over us. I mean, she's literally going to roll over us, crushing the case. And Mark Meadows writes, they say, this is why you were wrong. Number one, Mr. Meadows has at least a substantial case on the merits, all right? The court's own order, you said it yourself, Judge, that this case presents a novel question, which informed your own decision. You also relied on the state's novel theory of prosecution to distinguish numerous well-established precedents that favor removal for federal officers. So you recognize this is a new case. You then took the government's new theory and you just incorporated that. But the Court of Appeal is going to review those issues de novo, which means they're going to take a fresh look at it. They're not going to say, sometimes when you go to the Court of Appeals, they can only look at certain things, right? They can't look at the entire case. People will think, well, I want to appeal my case. That doesn't mean you get a second trial. It just means it's like a do-over. It just means that one portion of the evidence or testimony or whatever the problem was gets reviewed. And so sometimes that will happen, but sometimes they'll say, was there clear error? Was this an abuse of discretion that justified changing it? Other times they'll say, this is brand new. So they just took a crack at it at the lower level court. Let's see how they did. And if it's a brand new issue, they'll review it de novo, which means on their own, of new. There are several aspects of the court's remand order that depart from the ordinary removal precedent, and therefore Mr. Meadows at least has a substantial case on the merits before the 11th Circuit. Also, Judge, you were wrong when you failed to credit Mr. Meadows' account of his conduct and his duties. Said the Supreme Court has held that federal courts must credit the removing party's theory when determining whether he acted under the color of federal office. So in other words, Judge, you're supposed to take Mark Meadows' word for it. You didn't. You're supposed to. You're not supposed to just intersperse your own judgment into his thinking. You can't read his mind. In the remand order, the court departed from that rule and credited the state's allegations over Meadows' testimony, or they discounted Meadows' testimony. In the order, you credit the state's allegations that Meadow requested a memo on disrupting or delaying the joint session of Congress and that he attended a meeting about fraud in Michigan. They also say that he's inverting the standard for removal, right? So the judge is basically reversing what sides need to prove what. Both the statutory text, they say, Judge, and the binding 11th Circuit precedent make clear that if any portion of the prosecution is removable, the entire case is removable. That's the law. But in your order, this court effectively held the opposite, that the case should be remanded if there is any way the state could prove its case without relying on an official act. So in other words, she gave Fannie more deference rather than the federal official more deference. Think about an analog like in criminal law. Criminal law, we say the government has to prove the defendant guilty beyond a reasonable doubt. Well, that's our standard, but what about if we just said, in this case though, the defendant has to prove his innocence beyond a reasonable doubt? And what? That's weird. It's a burden shift. You're asking the other side to do something else. And the judge said, in sum, to establish a RICO conspiracy, the state only need to prove that any co-conspirator committed one overt act in furtherance of a conspiracy, whether the conspiracy was even charged in the indictment or not. In other words, the state can prove its RICO charge against Meadows by showing any one of his co-defendants committing any overt act in furtherance of the conspiracy, whether whether it's even in the indictment or not, which is kind of an insane standard. So, Meadows was a part of the conspiracy, regardless of the overt acts. He's on the team, whether the overt acts applied to him or not. Raising the burden. So now they're shifting the burden over to Mark. They say the threshold for removal is quite low. We've already seen that. But in the remand order, this court held Meadows to a higher standard. They effectively are requiring him to prove his defense and to justify the full scope of his duties in order to obtain the removal. There is a substantial possibility that the 11th Circuit will disagree on at least one of these issues that Meadows will raise on appeal. Therefore, we need a stay. Number 2, absent any stay, there's going to be a substantial risk that Meadows will be irreparably injured. Federal rights he invokes include freedom, but also the burdens of a state court defense. The irreparable harm has already begun. He was compelled to self-surrender on August 24th after Big Fanny refused a modest delay of his arrest. Meadows has been compelled to waive arraignment, post bond, begin preparing for a defense for a state prosecution for which he doesn't even think is legitimate. Meadows has sought to minimize his harm. He's asking the state to sever and stay his case. But to this date, the state court held a hearing but has not rejected the state's aggressive timeline. So, at a minimum, Your Honor, the court should stay the remand to protect Meadows from a conviction while he is appealing this. Absent a stay, the state will continue seeking to try Meadows 42 days from now on October 23rd. If the state gets its way, Meadows could be forced to go to trial, could be convicted, could be incarcerated before the standard timeline for a federal appeal would even play out. So Meadows' rights would be nullified. And third, if you just put a stay on this, it doesn't hurt anything. It's not going to prejudice the state or the other defendants. It's not going to prevent other proceedings. And so grant it. And lastly, a stay is in the public interest. The very premise of the Supremacy Clause and the immunity associated with it, along with the federal removal statute, is vital to a functioning country. If a state can proceed to trial and impose a verdict, it's going to give a very chilling effect to every federal law that goes out. And we don't want this case to become a shuttlecock, batted back and forth between both parties, the state courts and the federal courts. Therefore, the court should stay the remand pending appeal submitted by John S. Moran for Mark Meadows, Trump's former chief of staff, and submitted on the 11th day of September. And so you can see this was the two filings. The court came out, asked for very expedited briefings on this, and here is what they said. They say, all right, let's go fast. This matter appears before the court. Mark Meadows filed his emergency motion, and now Fannie needs to respond by 12 p.m. September 12th, 2023, signed by the judge, Honorable Steve C. Jones, U.S. District Judge. So this is a big speed bump in the road for Mark Meadows and for the removal process, because now they're asking for just a hold. And if the judge says no, well, the appeal is going to take forever to go through. And Fannie can just steamroll ahead with her prosecution.